sedition laws, which are under section 124 clause A of Indian Penal Code. So today we will have a brief discussion about sedition, and we will discuss about its history, what are the present cases and what are the past cases which have formulated the very structure of law and formulated the law on the basis of which we have to solve question if any question comes in the paper. So moving on to the next slide. So just tell me if the next slide is clear to you, is visible to you or not.
Slide is visible. Can you make it into a slideshow?
Yeah, I have made it, but is the second slide visible?
No, it's not visible because on the big screen only the title page is showing.
Okay, wait.
Yeah, now it's visible.
Okay.
So what's happened is the left hand panel is showing the slides and the right side is showing the slide, but it's not in a slideshow thing.
I have done it in a slideshow, but I think due to some network issue.
Okay, understood. We can go ahead like this, not an issue. Please go ahead.
Okay, then before discussing the history of sedition and anything related to sedition, let's first understand what sedition is. And while discussing the definition of sedition, we have to go through section 124 clause A of Indian Penal Code. In this section, sedition is defined as whoever words either spoken or written or by visible representations or otherwise brings or attempt to bring. These terms are very important, such as brings or attempt to bring into hatred or contempt, or excites or attempts to excite disaffection towards the government established by law. This is also a very important point, that the government should be established by law. Okay, note this point, that the government should be established by law in India. The person who has done this shall be punished with imprisonment for life, or to which fine may be added, or with imprisonment which may extend to 3 years, to which fine may added, or with fine. This is the general definition of sedition, which is there in section 124 clause A of Indian Penal Code. Now, sedition is a non-bailable offense, and punishment under the law varies from imprisonment up to 3 years to a life term and a fine, which we have discussed the punishment. And a person charged under this law can't apply for government job. This is also a very important aspect of sedition charge, that a person charged under this law can't apply for government job. They have to live without their passport and must prevent themselves in the court as and when required. Okay, so that they have to live without their passport so that they can't flee to, because government want to restrict their freedom to flee to other country. Because if the government requires them, the government wants them at the court, at the police station. So that's why government has restricted their passport. Okay, is the definition okay till now? Okay, so I am moving further on to the next slide. Yeah, is the next slide visible? If it's visible, then just message yes or no. Is it visible?
No, sir, we are on the first slide.
Okay, wait. Yeah, is now it visible? Okay, it's visible now. So moving on to series of events, what we are going to discuss now. So the first is introduction of IPC, Indian Penal Code, how it got introduced. Then second is introduction of sedition law. Third is first trial under sedition law, which is the Bangabasi case of 1891. Fourth is the Bal Gangadhar Tilak case of 1897. So at many other places you can find that there's Bal Gangadhar Tilak case, and the people refer it that it's the first trial under sedition law. But after well researching, I found out that the Bangabasi case of 1891 as the date, as the year is also mentioned, that the Bangabasi case is of 1891 and the Bal Gangadhar Tilak was of 1897. So Bangabasi case is the first trial under sedition law. So just remember it. So IPC got introduced uh, in 1860 by Lord Macaulay. And what happened that after 1857 revolt, Britishers tried to codify Indian criminal law because they wanted to suppress us. They wanted to criminalize the person who is doing any criminal act. They wanted to put the person in jail. So they have codified the criminal law. So in 1860, it was introduced by the Indian Penal Code was introduced by Lord Macaulay on the first law commission's recommendation. So, and the chairperson of the first law commission was Lord Macaulay himself. So, as being the chairperson of first law commission, he recommended of codifying the Indian criminal laws, and finally a new structure came, which is Indian Penal Code. Then, in that first law, which passed in 1860, which is Indian Penal Code, uh, there was no mention of sedition law. So, how it got into Indian Penal Law? Then sedition 1870 got introduced in chapter 4 of IPC. So we will discuss what are the circumstances which led to sedition law. So the first circumstance which led to sedition law is of 1857 revolt. As we have discussed that 1857 revolt also led to the codifying of criminal laws. All the criminal laws which are present at various regions in India which are practiced, they have been codified after the 1857 revolt. After observing the 1857 revolt, they have been codified on the recommendation of First Law Commission, which was headed by Lord Macaulay. Then the most important movement which led to the passing of sedition law, which led to the enactment of sedition law in the Indian Penal Code, is Wahhabi movement. So let's just a short bit discuss what's a Wahhabi movement. So Wahhabi movement it's a revivalist Islamic movement which tried to purify Islam by eliminating all the un-Islamic practices which had crept into Muslim society through the ages. It offered the most serious and well-planned challenges to British supremacy in India from 1830s to 1860s. And thus to curb those challenges, sedition law was passed. Okay, so sedition law was passed, got included in 1870 and got included in chapter 4 of IPC. It's in chapter 4 of IPC. So what happened that we were under illegal British occupation and we have to overthrow the British rule. We have to fight an ideological battle against the British rule because it was an illegal rule. So let's get the concept of sedition, because we have to know, we should know that why British government has passed sedition law. What's their main motive of passing sedition law? So it's very clear that we were under an illegal rule when the British government was here. So but the first step which we have to take is the propaganda. That means we have to carry on with our education propaganda. We have to educate the masses that time before the passage of sedition law, that we are under we have to tell the normal public of India, because independent movements are going on. We have to tell the normal public of India that we are under foreign occupation and we have to overthrow this illegal British occupation. Then how can we carry on this propaganda? There are four ways of carrying on this propaganda. The first way is through speeches, second way is through articles, third way is through writings, fourth way is through newspaper. It's a general discussion. It's not mentioned in the PPT. I just wanted you all to know the concept of sedition. That what is the main motive of Britishers for enactment of sedition. So the four ways which I have mentioned, which is that we have to carry on this propaganda of educating the masses that we are under the illegal occupation. The four ways are: first is through speeches, through articles, and then through writings, and then through newspapers. So it's through these means that we can educate and inform the masses that we have to come together on a single platform and launch a struggle for India's independence. Now, the British soon realized that if they allow Indians to carry on with this educative propaganda, then their days in India were numbered, and thus they have criminalized and restricted the freedom of speech and expression of Indian people. And because they have also observed the 1857 movement revolt, and also observe the Wahhabi movement. And for this, the purpose of the sedition was to because to criminalize the actions of Indian people to suppress their freedom of speech and expression. The sedition law was incorporated in Section 124, Clause A of IPC. So the primary objective was that we have to somehow prevent nationalist feelings from getting developed amongst the Indians. That's what Britishers wanted at that time. So they incorporated sedition law under Article 124, clause, under Section 124, Clause A of Indian Penal Code, which is in Chapter 4 of IPC. So moving on to, if there is doubt, then you can put in the chat box. Otherwise, we will move further. So this is the case. What all we have discussed is before passing of sedition law, and then sedition law was passed in 1870, and then after after in 1947 we got independent. Then after independence, what happened? A committee on fundamental rights, which was headed by Sardar Patel, and the committee added sedition as one of the ground on which freedom of speech and expression 19(1)(a) can be restricted. I think we have discussed already while we have discussed the Article 19(1) Clause A, 19(1) Clause B. At that point, we have discussed the freedom of speech and expression, and we also have discussed the restrictions which can be applied on freedom of speech and expression. And at that point, we haven't found that there is a restriction of sedition also. So let's check why the restriction of sedition was not there. So after independence, when Indian constitution was being made, when new laws for India was being made, because the new laws are going to determine the future of India. So a very good time was given to formulate those laws. So a committee on fundamental rights, which was headed by Sardar Patel, and that committee added sedition as one of the ground on which freedom of speech and expression, which is under Article 19 Clause A, subclause 19 Clause 1, subclause A, can be restricted. Then when this addition was introduced in the draft constitution, many people in the Constituent Assembly protested. Then ultimately, sedition ground was dropped as a part of reasonable restriction. That's why we haven't found the sedition ground while we discussed Article 19, Clause 1, subclause A. But then sedition was mentioned under Section 124, Clause A of IPC. It was removed as a restriction, but it was mentioned in IPC Chapter 4 and under Section 124, Clause A. That's the scene after independence. Then, after independence, as the sedition law was incorporated in the Indian Penal Code, there are many cases which has been in the Supreme Court against sedition law, and there are few important judgments in which Supreme Court has given its view, and they are also important as per currently. Also, they are important because if there is any case in the Supreme Court now, then Supreme Court checks the case as per the previous decisions which the Supreme Court has given in these three cases which are mentioned here. So the first case is of Kedarnath Singh versus the state of Bihar, which was of 1962. Second is of Balwant Singh case, which is of 1995. Third is Shreya Singhal versus Union of India, which is of 2015. Shreya Singhal versus Union of India is the most important and the most recent case, which is very important if you want to clearly understand what sedition is. Then coming to the first case, which is of Kedarnath Singh versus the state of Bihar, and held in 1962. In this case, the constitutional validity of the sedition law was challenged as per Article 13 of Constitution. We know that sedition as a restriction was removed from the Constitution, and then it was incorporated under under Indian Penal Code under Section 124A. Then it is the provision as per the provision of Article 13 of Constitution. Article 13 states that laws in consistence with or in derogation of the fundamental rights, all laws in force in the territory of India immediate before the commencement of this Constitution, insofar as they are inconsistent with the provisions of this part, shall to the extent of such inconsistency be void. So if any law is against the Constitution, is violative of fundamental right, if the law is from Contract Act, or if the law is from Indian Penal Code, if the law is from Evidence Act, then if the law is against the fundamental rights, then that law itself becomes null and void. And it's the duty of Supreme Court to mention and to make that law void. Okay, then Supreme Court stated, after checking whether the sedition law is valid or not and whether it's in abrogation of Article 13 or not, Supreme Court stated that the sedition law under IPC is valid, but we will narrow down the interpretation of the sedition law. So they have narrowed down the interpretation of sedition law, and they stated that we can't have sedition as well as freedom of speech and expression in the same breath, because though the sedition law was present under Indian Penal Code, it's a it's a direct restriction to the freedom of speech and expression, because by the help of sedition law we are controlling the freedom of speech and expression of people. So Supreme Court stated that we can't have sedition as well as freedom of speech and expression in the same breath. That is, we will give precedence to freedom of speech and expression because it's present in Constitution of India and it's a fundamental right also, and Constitution is the mother law. So we will give precedence to freedom of speech and expression. But if you are using your freedom of speech and expression, this is very important, that if someone is using his freedom of speech and expression to incite people to violence, then the person can be booked under sedition, and the person can be sentenced to 3 years in jail or life imprisonment. So you can exercise freedom of speech and expression, but that exercise shouldn't incite people to violence. That's what is stated in Kedarnath Singh versus State of Bihar, while narrowing down the interpretation of sedition law. Okay, is this much clear? Should we move further?
Yes, sir.
Okay. So coming to the next case, we are moving year wise. So the next case is of Balwant Singh case, which held in 1995. So let's check the fact of this case. So there is one group of people who raised slogan of Khalistan Jindabad. So raising slogans of Khalistan Jindabad is that they are asking for a separate nation by seceding the territories of India, and they want a nation as Khalistan. But they want to term the nation as Khalistan, and they want it as a separate part of India. Then there is one group of people who raised slogan of Khalistan Jindabad, and there was no incitement because of the slogans. These people who raised the slogan were arrested and were booked under sedition law for promoting disaffection against the government established by law. Matter went to the court. So what happened when they raised the slogan? Nobody got involved with them. Nobody got incited. Okay, nobody got incited. So there was no incitement because of the slogans. But what happened? They were booked under sedition for promoting disaffection under the government established by law. Matter went to the court. Supreme Court said in this case that it's very important to note that Supreme Court said that mere slogans, no matter how unpalatable these slogans are, they won't be deemed as sedition, because you have the freedom of speech and expression unless and until you are inciting people to violence, unless and until you are calling people to raise arms to overthrow the government of the day. That's what Supreme Court held in this. Is it clear till now? And then after, all the persons were set free because due to their slogans, there was no incitement. And in the Kedarnath case also, Supreme Court held that there needs to be incitement while exercising freedom of speech and expression. Only then the person can be booked under sedition law. And that's the same Supreme Court reiterated in Balwant Singh case. But Supreme Court clearly pointed out here that mere slogans, no matter how unpalatable, how destructive these slogans are, they won't be deemed as sedition because you have the freedom of speech and expression, unless and until it will incite the people. Okay, is this much clear about Balwant Singh case?
Yes, sir.
Okay, moving on to the next most important case, which is Shreya Singhal versus Union of India. As we have seen the cases of Kedarnath and Balwant Singh, Supreme Court has already come to a particular point that incitement is needed while exercising freedom of speech and expression. Only if there is incitement of people, then only the people can be booked under sedition law. So Supreme Court defined, in this case, Shreya Singhal, Supreme Court defined what speech primarily is all about. Supreme Court said that through your words, spoken or written, you can advocate, propagate. Advocate means either support or criticize. Propagate means you can means propagate. You have the right of freedom to propagate your religion, to tell your religion, to tell about your religion to each every other person. So that's the meaning of propagate. If you want to inform someone about the slogans, if you want to inform some of your opinions to someone, then you can do that thing. Then Supreme Court stated that through your words, spoken or written, you can advocate, propagate, but don't incite people to violence. And if you have incited people to violence, then that exercise of your freedom of speech and expression is wrong, and you can be booked under sedition. So Supreme Court stated that if because of your speeches there is breakdown of public order, you are violating the peace and tranquility in the state, then only you can be booked under sedition. This is the final in the Singer versus Union of India. So the main thing in these judgments, it's that there should be no incitement of people. If there is incitement of people while exercising freedom of speech and expression, then the person can be booked under sedition. Now, coming to some current examples which are there in the society for sedition law. So the first is the case of Sarjil Imam. It's this case is very famous because it's very widely discussed in many news channels. So if somebody is following the Hindu, somebody is following Indian Express, then they may be knowing Sarjil Imam and the case of Sarjil Imam. So what happened that cases has been lodged against Sarjil Imam for his seditious speeches and activity in 5 states. In 5 states, cases have been lodged against him. These 5 states are Delhi, UP, Assam, Manipur, and Arunachal Pradesh. So a two-judge bench of Justice Ashok Bhushan and V. Rama Subramanian had a plea by he was a JNU student Sarjil Imam. So had a plea by JNU student Sarjil Imam seeking to curb all FIRs filed against him for his speech during the anti-CA protest in Delhi. So the speeches which the person has given are during the anti-CA protest in Delhi. Then the Supreme Court on Friday, recent Friday, refused to stay the prosecution on sedition cases filed against JNU student Sajil Imam in various states, clarifying that the plea before the court is only for consolidation of FIR. It's the plea is for clubbing all the FIR. It's only for consolidation of FIR. But then also the lawyer of Sarjil Imam asked Supreme Court to stay the prosecution on sedition. Then Supreme Court said that we can't stay the prosecution on sedition because the plea which you have made is only for consolidation of FIR. Then Delhi court, as per current situation, Delhi court has extended the judicial custody of Umar Khalid, Sarjil Imam, and others till 1st March 2021. So whatever will happen after 1st March 2021, that will be news. We will read that. Okay. Till now, this is the condition of case of Sarjil Imam. Is everything okay till now? Can we move further?
Yes, sir.
Okay. Then there is a case of farmer protest journalist case. In this, several senior Indian journalists have been charged with sedition over their reporting and online posts about the farmers' protest, sparking criticism for media associations. So what happened? They made some posts, and these posts were in the last, these posts were found wrong. And on the basis of these wrong posts, many protesters did the protest. Many protesters participated in the violent protest. So that's why sedition case, they were booked under sedition cases. Then what happened? Then filed by the resident. The case was filed by the residents of the state. The cases allege that the journalist provoked violence during the protests by farmers, which is for the farms law, at New Delhi's Red Fort on January 26th through inaccurate posts. Inaccurate. The posts were inaccurate, which was found. It's evidentiary that the posts were inaccurate. So through inaccurate posts on Twitter and reports that police had killed a protester. They have reported in their post that police had killed a protester, though that's not the case. Then what happened that Congress leader and member of parliament Shashi Tharoor and journalist Rajdeep Sardesai have approached Supreme Court against multiple FIRs registered in different states for allegedly sharing unverified news about the death of a protester during the farmers' tractor rally on 26 January. And these FIRs were filed by residents of those states. So case is going on. This much, uh, this much is there, and the case is going on. If there is anything, we will discuss it afterwards. Okay. Then moving further. Now we have legal questions set, and yeah. This is the first question which we have to discuss. So try to do this question and then we will discuss it. Take 2-3 minutes. Okay, so we have got two answers here. I think we should discuss the question now. So in the question, firstly, section 124, clause A of IPC is defined, and it states that whoever by words, either spoken or written, or by signs. It can be either by words or whether the words can be spoken or written, or by signs, visual representations, or by visual representations, or otherwise brings or attempts to bring into hatred or contempt, or excites or attempts to excite disaffection towards the government, which should be established by law in India, shall be punished with imprisonment for life, to which a fine may be added, or with imprisonment which may extend to 3 years, to which a fine may be added. Okay. Then Sedition 124A has been challenged in various courts in specific cases. The validity of the provision itself was upheld by the Constitution Bench, been supported by the Constitution Bench in 1962 in Kedarnath Singh versus State of Bihar. So after mentioning the name of Kedarnath Singh versus State of Bihar, the passage gives the judgment, states the judgment of Kedarnath Singh versus State of Bihar. So the judgment went into issue of whether the law on sedition is consistent with the fundamental right under Article 19(1) Clause A, which guarantees each citizen's freedom of speech and expression. The Supreme Court laid down that every citizen has a right to say or write about the government by way of criticism or comment, as long as it does not incite people to violence against the government established by law or with the intention of creating public disorder. So coming on to the question states that there's a group of protesters which is protesting in Delhi, and they all started protesting in Delhi with the slogans that we will have the Jammu and Kashmir as a separate nation from India. Okay. Then the people protested for up to 1 hour, those protesters, but none of the other public got involved into the protest, and finally the protest ended. Okay. Protesters protested up to 1 hour. Then one person registered an FIR under section 124 clause A against the protesters. Okay, so now checking the options. A option states that the protesters have committed sedition as Jammu and Kashmir is part of sovereign India and the group is talking about its secession. Okay, so the group, yeah, it's clear from the question that the group is talking about its secession. But it's not mentioned in the passage that because of this talk, any violence erupted in the city. It's not mentioned in the passage. And we need what we need. We need violence, incitement of people. That's a major ingredient for the fulfilling conditions of sedition law. For after that, only people can be booked for under sedition law if there is violence, incitement of people, only them. So A option is wrong. Coming on to the B option. B option states that the protesters were not guilty of sedition as no violence was caused as an effect of their protest. Okay, this seems to be the right answer because no violence was caused as an effect of their protest. No people have joined their protest, so no violence has been caused. So option B can be a right answer, and it seems to be a right answer. Coming on to the option C, let's check that also. Option C states that the probability of eruption of violence in the future due to this protest was very much there. So the group is liable for sedition. Okay, let's discuss this point also. Are we going to consider, should we consider the probability of eruption of violence in the future while discussing sedition? No, there's no need to discuss whether there is a probability of eruption of violence in the future or not. The violence should be at the time of protest. The seditious speech should incite the people at the time of the speech only. Okay, 1 second, there's one thing. Okay, yeah. So C option is wrong. Coming on to the D option, there's a question also related to D option, that whether D option is a suggestion or not. So let's check. D option states that the protest was only of 1 hour, but it had serious effect in the mind of people. So the group is liable for sedition. No, D option is not a suggestion. It ha it can be, it must have been a suggestion if it states that the protest was only of 1 hour, but the protest had serious effect in the mind of people. So we should throw out protesters. We should throw out protesters. We should book the protesters. If this has been mentioned in the option D, then it has been a suggestion, but it's not mentioned. It's very clear. It's a fact that the protest was only of 1 hour. It's just a statement. The protest was only of 1 hour, but it had serious effect in the mind of people. So the group is liable for sedition. It is just drawing a conclusion that the protest was only of 1 hour, but it had serious effect in the mind of people. Then drawing from this, we can say that the group is liable for sedition. This option is wrong, and this option is not a suggestion also. Okay, great. If you got the clear line between them, great. Now, moving on to the second question. Is there any doubt in this question or should we move? Okay, moving. So this is the second question. Try doing it. 2-3 minutes. Take 2-3 minutes. 1 second, 1 second. It's not changed. Let me check. Yeah. So this is the second question. Take 2-3 minutes to do this also.
So,
Yeah, yeah,
doubt.
yeah. Just
So
point out.
ideally, that 5S guy must be, guilty for receiving funds, but not for protesting, right? Or else, no, sir, I've given my answer.
So we will discuss the options of this question, and then we will try to solve it out. Okay. So let's start discussing this question. This question has the same passage in which there's a definition of sedition law. Then there's a mention of Kedarnath Singh versus State of Bihar case, and then its judgment is mentioned there. Then coming on to the question. So the question states that there's an student activist leader whose name is Fayaz Ahmad, and in his rally in Jammu and Kashmir, he said that the government is making policies with the aim of encroaching fundamental rights. Okay. Then he said that the government is working ultra vires, means outside their prescribed power, outside their authority. That means ultra vires. Government is working ultra vires, and we should show government the power of people. Okay. Then the rally went peaceful and had no violent after effects. This is clearly mentioned that the rally went peaceful and had no violent after effects. Then a next line is mentioned. In that line states that in the further investigation, it was clear that Fayaz used to receive funds from Pakistan militancy group Al Qaeda. Okay, that itself is wrong. That if he receives funds from Pakistan militancy group Al Qaeda, that's a wrong. But what we have to decide now? Should we are going to decide that whether the person who is receiving funds from Pakistan militancy group is liable or not? What we are going to decide is whether the person is liable for sedition or not. We are going to decide this thing. And for sedition, the major criteria is that while giving speech, Fayaz Ahmad, giving speech, Fayaz Ahmad should have incited the people uh, violence. But what's mentioned in the passage in the question that the rally went peaceful and had no violent after effects. And let's also check what Fayaz Ahmad stated. Fayaz Ahmad stated that the government is making policies with the aim of encroaching fundamental rights. This is a very common thing. Everybody can say, every person has the different view of opinion, has a right to criticize the government policies, and any person can say that government is making policies with the aim of encroaching fundamental right. Okay. Then what else he's saying that government is working ultra wires and we should show government the power of people. Okay. Every person has the right to mention, to show, to say in news debates, to say in speeches that the government is working ultra wires. And what he's trying to say that we should show government the power of people. How can you show government the power of people? So India is a democratic country. There's a democracy in India, and it's a rule of people because people elect their representatives. So one way of showing the power of people is by is not voting that the same government again in the elections. So that can be a way. So we can't say that if he's saying that we should show government the power of people, it's not inciting violence because the rally went peaceful and had no violent after effects. It also told in the future that after effect there's no violent after effects in the future also, and the rally also went peaceful. So now let's check the example options. First option states that Fayaz Ahmad was liable for sedition as he was working for Pakistan militancy group Al Qaeda. We don't know that this working with Pakistan militancy group Al Qaeda is a ingredient for checking the conditions of sedition or not. Because whatever is there mentioned in the passage before the question, we should only know that much knowledge. Because CLAT consortium has mentioned that you don't need to have prior knowledge of the law. Just know whatever is mentioned in the passage, and there is nowhere mentioned in the passage that if you have any connection with any terrorist organization, then you can be booked under sedition. as per law, current law, then if you have any connection with any terrorist organization, then you can be booked under an act which is UAPA Act. You can be booked under that act. But we don't have to know that act also as per this question, because there is no mention of any terrorist organization. That the connection of terrorist organization can be a point for booking the person under sedition. It's not mentioned in the passage, then we don't have to consider that point. So option A is that's why wrong. Okay. So yeah, option A is wrong. Coming to the option B. Option B states that this is a question of sovereignty of India and Fayaz was liable for sedition. Okay. So every question related to sovereignty of India didn't give rise to a case, didn't give rise to start of a case for sedition. You can't book any person if he gives speech against the sovereignty of India, because that speech should result inside should incite people to violence. Then only the person can be booked against under sedition law. Okay, so option B is wrong. Coming to option C. Option C states that Fayaz was not liable as there was no public violence caused. Yeah, there's no public violence caused. Rally was peaceful and it doesn't have any violent after effects also. So Fayaz was not liable as there was no public violence caused. C option seems to be right, but let's check D option also. D option states that Fayaz can receive funds from any place and he was not liable for sedition. Okay, D option can also be a right option, but that D option doesn't talk straightforward. What we need, we have to check whether violence is caused or not due to the speech. We don't have to check that Fayaz can receive funds from any place. Anything related to fund is not mentioned in the passage. It's not mentioned in the principle. What we have to check that whether if there is violence because of the speech, because of the exercise of freedom of speech and expression, then there is sedition. If there is no violence, then there is no sedition. And it's clearly mentioned in option C that Fayaz was not liable as there was no public violence caused. This is the straightforward option. So option C is the right option and option D is the wrong option. Okay, is this much clear? Should we move to the next question? Okay, so next question has the same passage. Then it states that suppose in the above question, which is the Fayaz Ahmed question, suppose in the above question, everything is same, but Fayaz was not receiving funds from Al Qaeda. Then what should have been your answer? Mention your answers. This is a simple one. Yeah, definitely answer will not change because there's nowhere mentioned in the passage that receiving of fund can be an ingredient. It's not mentioned. So whether he is receiving fund or not receiving fund, the answer will be same. If answer will be same till the rally is peaceful, till it has no violent after effects. Okay, is this much clear? Or do you have any doubts in the three questions? Okay, just check the answers. These are the answers. And if it's clear, then we
So
should
can
go.
you please show the first 3 slides? I need to have a look into it. Please.
Okay, yeah, definitely, sure, I can.
Nagalakshmi, try and be on time because you're missing a lot of stuff at the beginning and then you make the teacher make you go through the slides again. Okay?
Yes,
so, yeah.
Ma'am, I had a severe power cut here. We are getting again and
yeah,
again.
but you have to figure out a way to circumvent that and be on time because for every class you have the same excuse.
Yes, ma'am.
Okay, so should I explain this slide also or is it okay?
So it's okay. If you can explain, then I'm really grateful for that. But I got the idea back.
Okay, so the first slide defines what sedition is. Sedition can be caused by words either spoken or written, and it should attempt to bring into hatred or contempt or attempt to excite disaffection towards the government established by law. You have to mention this point that government should be established by law. If the government is illegal and you are inciting people to be violent against that government, then then that would not be sedition. Government established by law is needed to be there. Okay, then only you can be punished for imprisonment of life or imprisonment for 3 years under the sedition law. Sedition is a non-bailable offense. Just remember this. So one more thing. If all of you are there, then I want to mention one more thing. Yeah, all of you are there. So the one more thing which I want to mention is that in 2020, sedition law has completed its 150 years. So now the topic sedition has become very important because it's 150th anniversary in 2020, just in 2020. So you can expect, I think, I can't say very surely, but I think that you can expect one question from sedition. So just revise the PPT, okay? Then the second slide is series of events, which is introduction of IPC and then introduction of sedition law. IPC got introduced in 1860, sedition law got introduced in 1870, and the first trial under sedition law is of Bangabasi case. The second trial is Bal Gangadhar Tilak case of 1897, and then the slide states the same thing. And what led to sedition law? Two kind of revolts are there which led to sedition law. First is 1857 revolt, but the major role is of Wahhabi movement, which caused sedition law. It's a revivalist Islamic movement, due to which Britishers faced many problems, and they tried to curb that movement by incorporating sedition law under Indian Penal Code, which was introduced in 1860.
Okay,
Okay.
sir. I just missed the first two slides actually. I was here since like the introduction to 1860 by Lord. Yes. Thank you, sir.
So can we go ahead and end the meeting?
Yes, ma'am, we can, I think.